Hello and welcome to everyone watching the second in our 12-part series of Law Tech 365 webinars. This month's webinar focuses on client onboarding, AML and compliance for law firms. I'm Mevlud Njihich. I'm the presenter for this particular webinar, and I'm an expert in AML for law firms. I work at Verify 365, which is a remote verification process system for law firms in the UK and Ireland. And today I am joined by Paul Smith from Travellers, Andrew Bryan from the SRA, and Lubna Shuja from the Law Society and Sole Practitioners Group. It's lovely to have them all on. The format for this webinar is Mr. Smith, Paul Smith, will walk us through a presentation about factors around AML, what law firms need to look out for, risk factors, and so on. After that, we will then be proceeding to our question portion, where we will be speaking directly to Andrew and Lubna, asking them direct questions about AML and law firms, specifically focusing on the technology aspect as well. Viewers and watchers and listeners, anyone who's really taking part in this webinar in any format, are encouraged to ask questions to our panel by making notes in the LinkedIn post below. All questions will try to be asked towards the panel as best as possible. Any questions that we don't come on to, apologies in advance. With that being said, we will go straight into the presentation that Paul has prepared. So with that, I'm just going to quickly share the presentation. And Paul, when you're ready, feel free to get going.
That's great. Thank you very much, Med. Good afternoon, everybody. This is a short review of money laundering and AML requirements as they affect solicitors as at January 2022. Before I get into the presentation, though, if you can just go to the next slide, please, Mev. I need to share this disclaimer with you. There's a lot to take in. We've only got 20 minutes. So here's a disclaimer, précis. This talk is for guidance only. There's no liability over the information supplied, which is also not exhaustive. Any image you see, we can use because they're copyright free or we've got the right to use them. So précis of the précis is that terms and conditions apply. Next slide, please. So anti-money laundering. We're going to be looking at, next slide, please. The following, what money laundering is and why it's an issue, regulatory, legal structure around anti-money laundering, risks for lawyers, and how to control money laundering and based on SRA guidance. I thought we'd kick off with a definition of money laundering, so we're all clear what we're talking about. It's the generic term used to describe the process by which criminals disguise the original ownership and control of the proceeds of criminal conduct by making such proceeds appear to have derived from a legitimate source. Now, the definition there comes from the International Compliance Association, in the ICA. This is a professional membership and awarding body, the leading global provider of professional certificated qualifications in anti-money laundering, governance, risk and compliance, and financial crime prevention, according to the website. It's got around 140,000 members, which gives you some idea really about the amount of money laundering which is going on out there and which needs to be combated. Next slide, please. Money laundering, who and what it involves. I'm going to start with the people. There are a number of groups which would like to disguise the source of funds. And in his book, Moneyland, which was published a few years ago, the investigative journalist Oliver Bullough identified 3 groups with varying levels, in his view, of moral or legal culpability. You start off with the scared. So these are people who want to protect their assets from perceived threats. Maybe they're in a jurisdiction where their government's threatening to expropriate their property. Maybe there are criminals who want to steal it and they want to smuggle assets out of the jurisdiction. Their only crime might be breaches of export or exchange controls in their own country. Then you have the naughty, defined by Bullough as tax evaders, and then finally the wicked, a range of crooks, despots, drug dealers, people who've managed to abuse their public position or get their wealth, amassing that wealth through abuse of public office or through crime, and they now want to get out. Often they're in countries where there's little to buy. They're countries which are pretty poor, and they've probably been made poorer by these people's actions. Next slide, please. So in terms of what money laundering involves, there are key components here, which I put on the slide. Processes are extensive. Generally speaking, money is laundered whenever a person or business deals in any way with another person's benefit from crime can occur in a lot of different ways. But traditionally, the process, it takes 3 distinct stages. So you start with placement, the stage at which criminally derived funds are introduced into the financial system. Lots of ways you can follow, lots of processes to launder money, and you can do it without the assistance of the financial sector. But the reality is that hundreds of billions of dollars of criminally derived money is laundered through financial institutions every year. And the nature of the services, the products offered by the financial services industry, so managing, controlling, possessing money and property belonging to others, means that it is vulnerable to abuse by money launderers. And there's also evidence of banks turning a blind eye, being willing to do that with dubious characters, dropping their own due diligence procedures if they think that the rewards outweigh the risk. The next step is layering. So the substantive stage in the process, this is when the property is washed and the ownership and source is disguised. And the methods here often include shell companies, so complex commercial structures hiding true ownership. And then finally, integration. This is when the laundered property is reintroduced into the legitimate economy. Now, because money is globalized and law enforcement stops at borders, tracking what happens to the money next or recovering is virtually impossible, especially with banking secrecy and the true use of trust. So in this way, the scared money gets mixed up with the naughty and the wicked money. And by this stage, the scared have found a safe haven, the evaders are getting a larger return on their gross financial assets, and the wicked can start to build up bolt holes for their future lives in stable jurisdictions. Property is a favorite, and we'll touch on that again later. London has a lot of what Bullough calls empty house-shaped bank accounts. This is a fairly simplistic approach to setting out what money laundering involves. Stages can overlap, and in some examples of financial crime, there's no real requirement for the proceeds to be placed, and solicitors can be involved in any of the 3 stages. In terms of the authority's response to money laundering, next slide, please. It's the Financial Action Task Force, one element of that response. This is an independent intergovernmental body. It was created back in 1989 following a meeting of the then G7 countries, so the group of 7 leading industrialized countries in Paris in 1989, and it promotes policies to protect the global financial system from money laundering, terrorist financing, and the financing of the proliferation of weapons of mass destruction. Now, the UK is a founder and current member of the FATF, which recommends and monitors AML actions. Next slide, please. In terms of the money laundering or the anti-money laundering legal framework, we start with the Financial Action Task Force. So it makes recommendations, and those can be passed on, for example, to the EU, which implements AML recommendations through EU directives, which national governments of the member states transpose into law, and that informs regulators and their responses. The 5th Money Laundering Directive was brought into force in December 2019. Now, of course, we've left the EU, so what's the impact of Brexit? Well, according to Amy Edwards of Allen & Overy, quoted back in January 2020, the UK is a founding member and strong supporter of the FATF, setting global anti-money laundering and counter-terrorist financing standards. Even following Brexit as a leading member of FATF, the UK will continue updating anti-money laundering policies according to international standards, so possibly not much of a change due to Brexit there. Come to the next slide, please. Some background on lawyers and fraud from the FATF. The report on the slide, this was commissioned back in July 2012 to establish how vulnerable legal professionals are to money laundering and provide some indicators, some red flags which might assist regulators and practitioners to prevent money laundering. So it was based on evidence from experts and organizations working on money laundering issues around the world. And I think its findings, nearly 10 years on, are still relevant to the issues of lawyers and fraud. Key points, if you could just hit the button again to bring up the text. That's great, thank you, Meb. Greater use of anti-money laundering provisions by financial institutions and the chance of being detected led to, at the time, and continues to lead criminals to use lawyers to assist in money laundering. The perception here that lawyers are probably less secure, and they also add legitimacy to a matter. Money laundering can appear in a number of different areas of work. I'll touch on that again in a moment. But property transactions, trust and company creation and management, undertaking litigation, setting up and managing charities, misuse of client accounts. Lawyers' responses during transactions where money laundering has taken place range from being alive to the red flags, acting on them, to missing them, due to inadvertence or lack of due diligence, to willful blindness and ultimately complicity. And sometimes the lack of action is due to the fact that the instructions relate to work which is typical for clients with legitimate means. On the face of it, there's nothing to alert you about the possibility of money laundering in this particular matter. And then finally, certain features of legal practice, holding client monies, client confidentiality, privilege, can cause lawyers to over-identify with clients and also give prosecutors pause for thought about their ability to gather the necessary evidence and mount a successful prosecution. So all of these factors tend to make lawyers attractive to money launderers and other fraudsters who see similar advantages in using and targeting lawyers. Next slide, please. Money laundering in the UK. So the UK's National Risk Assessment of Money Laundering and Terrorist Financing in 2017 provided an overview of the money laundering environment and the legal response. There's specific reference in this report at pages 49 to 54 to legal services, and the SRA based its AML guidance on what the National Risk Assessment had to say. Next slide, please. In terms of legislation, as you recall in the past, there'll be directives coming out of the EU, and in future that won't be the case. Current legislation is based upon the Money Laundering and Terrorist Finance Amendment Regulations of 2019, which came into force on the 10th of January 2020, derived from the 5th Money Laundering Directive from the EU and from the FATF's recommendations. So there was a broadening of scope of businesses, crypto asset exchange providers, custodian wallet providers, high value art market participants, property letting agencies, seen as potentially vulnerable to laundering money. And as far as solicitors were concerned, it was something of a gloss on the existing regime. Solicitors were already within scope, but the SRA still expected solicitors to take on board the need to update money laundering, anti-money laundering arrangements. So the legislation, I think, was enacted at the end of December 2019 and came into force in January 2020. So I imagine for quite a lot of people, something of a scramble to make sure they were compliant. Next slide, please. In terms of the risks, because AML legislation and guidance is extensive, for this presentation, I'm going to focus on one information source in particular, the SRA's Sectoral Risk Assessment on Anti-Money Laundering and Terrorist Financing, which was published in January of last year, although I will be referring as we go to other guidance along the way. In terms of the purpose of the Sectoral Risk Assessment, the SRA flagged up that AML in the UK is risk-based. That approach is embedded in UK legislation and best practice around AML. So it means that firms should target their resources on the areas or products that are most likely to be used to launder money. That targeting approach applies also to the SRA, taking a risk-based approach, directing resources with the most intense supervision on those involved in areas which are most likely to be used to launder money. Part of that involves asking firms for their own risk assessment as part of the routine monitoring or in response to specific information they've received. That assessment should not be disclosed to customers or third parties. In large part, this is based on the 2017 National Risk Assessment I've just mentioned. Next slide, please. In terms of the level of risk identified by the SRA, what they say is the risk is the likelihood of money laundering or terrorist financing taking place through your firm, and it's the level of risk, it's the inherent level of risk which is involved. So that's before any mitigation. It doesn't refer to the residual risk that remains after you put mitigation into effect. Risk can exist in isolation or a combination of factors that increase or decrease the risk posed. There are a number of different risk factors which are considered. What I've done for the purposes of this presentation is focus on a few key risk factors. What the SRA say is that none of the risk factors are forbidden in and of themselves. They're not a reason to withdraw from offering services. It's really a case of being aware of the risks that are present, manage them properly, and keep themselves and the public safe, because doing that correctly means there are services which can be offered which meet legitimate social needs. Next slide, please. So, starting off with some product and service risk. These are the areas identified by the SRA as most at risk from money laundering. Conveyancing, I mentioned earlier, those house-shaped bank accounts in London. And property is attractive as an asset for criminals because you can move large amounts of money with a single transaction, and property appreciates or can be used to generate a rental income. Something like half of the suspicious activity reports which are received each year relate to property transactions. So it's a measure really of how popular this is as a way of laundering assets and money. Client accounts, criminals see this as a way of tapping into that legitimacy, washing funds, and linked in with the banking facility. We've had cases where firms have allowed their client account to be used as a banking facility, but as the SRA has pointed out, you need to have an underlying transaction to relate to any given transaction through your client account. Trust and company formation, structures facilitating anonymity can disguise sources or destinations of assets, especially those opaque corporate structures I referred to earlier. And tax advice, potentially, certain types of tax advice can stray into the area of evasion. And there's also referenced in the report to the use of family offices. Next slide, please. In terms of client risk, a key area here, politically exposed persons. They can be from the UK or abroad. They usually have access to public funds or significant public interest, and the money laundering regulations require PEPs and their close family members to be checked to mitigate the risks of corruption. It's up to you as a firm under the money laundering regulations to be able to identify PEPs and their associates and undertake enhanced due diligence. Also, customers from cash-intensive or risky sectors of business. So, for example, things like the arms trade or casinos. And also, we've got familiar clients. You may become complacent about those people. You know them. You think you know what they're about, where they're coming from. You need to be able to verify information about the client and ensure all checks have been done. And also, employees pose a unique risk when they may be in a position to avoid controls. Clients seeking anonymity who can't prove their identity. Sometimes this is understandable if clients can't produce identification documentation, if they're elderly, if they're illegal immigrants. But where clients are evasive about producing evidence of identity or produce non-standard documentation, that should be considered higher risk. And finally, intermediaries and agents. There's nothing wrong in being, there may be perfectly good reasons for clients who seek to engage through an agent or an intermediary with a law firm, but it's going to make it more difficult to understand who your underlying customer is or client is. And it also creates the risk that the third party or agent doesn't have the appropriate permission to act on behalf of the customer. Next slide, please. Some further client risk factors, beneficial owners. Risks here, you need to be confident you know who your client is, why they're asking for your services. Any risk you do not should be duly considered. And also existing clients. Clients may be onboarded for relatively low risk work, and then that may be a way of bypassing due diligence or more stringent due diligence when more risky work is taken on in the future. Also be alive to the fact that clients may be onboarded from another firm, which has since merged with your own. They might be ported from a foreign branch office. They might be onboarded by a consultant or an individual who may not be applying the firm's approach consistently. So it's really about effective ongoing monitoring of all clients as the best control against these risks. Next slide, please. So some warning signs, clients who want to appear to want anonymity, acting outside the usual pattern of transactions, difficulty in identification, verification, being evasive about providing ID documents, and pressuring you into a particular course of action. Next slide, please. Further issue is source of funds. This comes from the SRO's warning notice from 25th November 19. Some warning signs here. Next slide, please. Large cash payments, unexplained payments from the third party, large private funding doesn't fit the business or personal profile of the payer, loans from non-institutional lenders, use of corporate assets to fund private expenditure of individuals, and the use of multiple and foreign accounts. So a lot to take on board. In terms of emerging risks, a number here identified by the SRA. So COVID-19, economic disruption may have left firms vulnerable to move into perhaps new and unfamiliar areas. Criminals might be able to exploit that. Maybe there are weaker controls, less face-to-face interaction means more reliance on verification of identities through technology. And there may be issues here about the extent to which people are using those properly. Also issues around technology when it comes to, say, fund transfer systems, crowdfunding platforms, and the risk in cyber. Wider economic pressures, because firms are under financial pressure because of the impacts of COVID, and also the legal status of cannabis, legal abroad, but the proceeds of that coming into the UK could be treated as the proceeds of crime. The SRA has seen some issues when it's been looking into this area in detail. So weak controls, screening, source of fund checks, independent audits, matter risk assessment. Also, evidence of an overly simplistic approach towards politically exposed persons and keeping track of those. And finally, an over-reliance perhaps on external support, external consultants helping firms to meet their AML obligations. So in terms of the profession's obligations, key ones really: understand the legislation. Are you within scope? Almost certainly will be. Making a firm-wide risk assessment, maintaining policies and processes to support your AML effort, and submitting suspicious activity reports to the legal sector. Whilst we're seeing more reports going in, traditionally has had a fairly low reporting rate compared with others. In terms of controls, more generally, firm-wide risk assessment I mentioned, and also independent audit of AML policies, controls and procedures. Make sure you've got a clear rationale for your service, source of funds are clear. The use of electronic identification and verification tools, especially when we're having difficulties with getting face-to-face, and also employee screening. The additional sources I've mentioned here, I've drawn on, but are worth looking at more detail to give you more of the background to what's required for managing AML risk. Finally, last slide, please. It's the takeaways. We've covered the rationale for AML regulation, the scope of it, and the threats to lawyers, and the obligations you're under to manage this risk, and the controls which are going to be applicable to doing so. So that's the end of the presentation. Thank you.
Wonderful. Thank you so much, Paul. Before we move on to the questions, I do remind all of our viewers and listeners that questions are encouraged. We will try our best to put your questions towards the panelist to be answered. With that in mind, Paul, you covered some fantastic things in there. And to remind everyone that this webinar will be available after the event, so you can rewatch that presentation. Some specific points we're going to focus on is the use of technology around AML, specifically around verifying client identity and source of funds and their finances generally. One point I thought was very interesting throughout the slide is weak processes within law firms and their practices. And having worked with many law firms myself, I've realized that actually a lot of law firms do verify their clients by asking them to come into the law firm and simply providing a copy of their passport and driving license. And for the risks that Paul mentioned in his presentation, we can quite see clearly that those kinds of checks and balances around AML, ID verification really aren't up to scratch. We're seeing lots of fraudsters, lots of illegitimate people who are trying to launder money through the use of technology. And with that being said, we're now going to go on to the questions to Andrew and Lubna. Well, Andrew, we will start with yourself. And I do have my questions prepared right in front of me. So if I'm sounding like I'm reading them out from a cheat sheet, apologies, but I am. Last year in 2021, the SRA held the compliance conference in Birmingham. There was a panel on technology and compliance, and we were actually one of the expert speakers on that particular panel, which was very nice of the SRA to invite us. Throughout that panel, one thing came clear, and that was the SRA are pushing very hard for technology and the benefits of technology in the legal industry around AML. There's also a wider push, but there's a very hard push within AML. What I've seen working with many, many law firms today, yesterday, throughout my entire career, is there is a risk aversion to technology to the point where some law firms just don't want any technology. So I asked this: what are the main reasons that the SRA are now pushing technology, specifically around AML, versus, say, 3 years ago, 5 years ago, or 10 years ago?
Okay, well, thanks for the question and thanks for having me. So there's been significant advancements in technologies with application in the legal sector in recent years, and we can see that their use is becoming more widespread. And supporting innovation and technology is one of our 3 key objectives set out in our corporate strategy that you can find on our website. Certainly, as an organisation, we want to do whatever we can to facilitate tech innovation where it enhances the delivery of legal services and can ultimately make life easier for consumers, especially with, identity verification and that sort of thing. So, at the moment, I feel tech advancement is gaining momentum and that use of tech in future will be starkly different to what it is today. So, we're keen to support use of tech and would encourage service providers to reach out to us if they need any kind of regulatory views on their solutions.
Do you think the legal industry, Andrew, is playing catch up slightly to, say, the financial industry and fintech?
I think the legal sector is sort of a tougher nut in that there are many more businesses that run their businesses in many different ways using different case management systems. There are literally thousands of them out there, so it's much more difficult to have kind of a uniform technology approach that can be used by many at once. So I think the progression is slower, but I think as I say, there'll be wider adoption as time goes on.
Amazing, thank you. Luna, stepping away from the regulatory side of things and looking at lawyers and law firms specifically, I appreciate that behind you it says the Law Society, but you actually also join us from the Sole Practitioners Group. And in the case of groups like the Sole Practitioners Group or anything like that, in terms of tech, specifically around AML technology, what kind of key factors do you think lawyers and law firms need to look out for, whether big or small law firms, when choosing technology and making sure that it's compliant?
Hi, good afternoon, Mev, and thanks for inviting me to come along and speak today. And yes, as you've indicated, I am here in a dual role today. I'm a member of the executive committee of the Solicitor Sole Practitioners Group, but I'm also the Vice President of the Law Society of England and Wales as well. So what I'm going to talk about a little today is how both of them are supporting members. For smaller firms and sole practitioners who don't have the in-house expertise that many of the larger firms have got, I think one of the key things that we need to do is it's really important to demystify what we mean by law tech. And we need to do that by providing advice and materials to help practitioners make informed choices about the technology that they are thinking of using within their organisations. Now, the Law Society, on our website, we have quite a bit of information around law tech, and in particular, we have a guide which is called the Introduction to Law Tech, and that's trying to help our members understand, well, what does law tech actually mean? How does it apply to me? What am I looking at? How is it relevant to me? And that guide is particularly aimed at smaller firms and sole practitioners who won't have the resources or may not have the resources of larger legal businesses when they're looking at adopting new legal technology. It's a very practical guide to law tech. It takes practitioners through the potential benefits of solutions, and it talks about things like increased efficiency, productivity, and growth. It talks about how you can reduce costs through the use of law tech, and it talks about how you can use law tech to lead to better outcomes for your clients. And the main thing is to stress that law tech is not there to replace lawyers or to replace the work of lawyers. It's there to enhance the work that lawyers are doing and to help them to deliver better efficiencies. And the Law Society Guide, it goes through a rundown of the types of law tech products that are currently available. So it talks about common platforms, it talks about document review, it talks about machine learning and artificial intelligence tools. So, things like reading contracts in different languages, performing due diligence. It's able to detect patterns in data, or you can use it to apply to new data, which will know what the outcome should or shouldn't be. So it can kind of flag up things that you need to be aware of. So by providing that kind of guidance, we are trying, certainly at the Law Society, to make sure that the benefits of innovation are open to everyone in the profession. And that will help to lead to a more focused, efficient legal sector, delivering the best outcome for clients. But we can't talk about the advantages of technology without talking about some of the threats as well. And as we come out of the post-pandemic world, we've got to look very, very closely at the challenge of cybersecurity. And I see in the chat, I can see somebody's asked a question around the global threat regarding digital transfer and how to protect the interests of consumers in the present world. And I think, one of the key things actually is that firms need to have the very best security to keep their data and by default, their clients' data very, very safe. So, you know, practices that are looking to make use of law tech, they face a number of regulatory and professional conduct challenges, and they've got to address those at the design stage and the procurement stage by doing really comprehensive risk assessments.
Wonderful. Oh, the 2 points that you mentioned there. One is, thank you for addressing the user that posed the fantastic question about consumers. Mr. LinkedIn user who has made himself anonymous, and Rudy Keswick. We will get onto your questions next, actually, for Andrew. But I also want to address something that Lubna said with regards to having too much, what's the best way to put this? Relying too much on technology versus relying too much on lawyers, because we will circle around to this point later down. Referring back to the 2 questions around endorsement, this plays quite nicely into the next question I want to address to you, Andrew, which is compliance technology around AML, such as Verify 365 and others. They will naturally permeate the legal industry because lawyers are looking at ways to protect their practices, and technology firms and vendors like ourselves are looking to support them. With the law tech industry constantly growing, with new players constantly entering the market, do you think it's the duty of the SRA at some point to actually have some sort of endorsement badge or SRA approved badge for technology providers so that law firms know that they are compliant, they're trustworthy, and so on?
I think, you know, that it does make sense for service providers to carry some sort of accreditation mark whereby users can have confidence that a solution meets a certain standard of compliance. Now, it's not something we're doing at the moment, as we don't have the resource or expertise to create and maintain a list of accredited providers, but this could change in future. Like the government in the UK is making moves in this direction and has established, you might have heard of the Digital Identity Trust Framework, through which schemes can be established that accredit service providers if they meet a standard of compliance. You know, I understand this is taking shape, particularly between the Home Office, the DCMS and DBS, to allow employers, landlords and letting agents to use certified digital IDV technology to verify individuals. So there are movements in that direction, and hopefully we will, you know, join the pack as time goes on.
Wonderful. So not yet, but potentially in the future is what you're saying.
Yeah, precisely.
Wonderful. Wonderful. Sticking on with that then, although I mentioned that the legal industry legal technology industry right now has many new technology vendors coming in and joining the market and offering their services. Historically, and this is only a couple of years ago, there were only a few big players in the industry, and most of those players had their tech designed, you know, early 2000s, 90s, where, excuse me, where the client would send in their documents to the law firm, and the law firm would actually just scan it through their system, and they would come back with either compliant or not. There's no real check or balance there to really confirm, you know, the ID is real, the person is who they say they are, their finance is verified. So the question is this: legacy systems which are 10, 15, 20 years old that designed their tech that long ago, can they be compliant? And this really plays into the whole approved SRA badge.
Yeah, that's a good question. You know, I think some unchanged systems can be compliant, but what you've asked gets to the core of a certain issue that we've seen many times, where certain legal firms might not make the effort to fully understand the tech solution that they built into their processes. Obviously, it's their responsibility to form this understanding to ensure they're compliant with our standards and the money laundering regulations in this context. Specifically, a lot of ID and corporate CDD tools might not use up-to-date information, and there's a risk that they draw on aged or limited data, kicking out a green tick approval result. And this, you know, those solutions might have missed a change in ownership or a criminal conviction, for example. You know, the green tick might look good, but the data upon which that approval is based might not comply with the firm's obligations under the regulations and has to be understood properly. So I'd urge firms to please be aware and ask probing questions when salespeople are trying to court your firm into spending money on a solution, such as, you know, how often their data is refreshed and what sources they draw upon. I mean, otherwise, you know, I'd recommend referring to Fatf guidance on digital ID and the LSAG guidance, the Legal Sector Affinity Group guidance, which has a section on the use of technology and, of course, the specifics of the money laundering regulations demand.
Amazing. The one point you mentioned there about salespeople and trying to sell law firms technology. One big gripe that I have is that many many technology firms out there that do claim to be compliant, although I'm not saying they're not compliant, they are compliant across multiple different sectors. So if anyone is, well, I'm sure someone's watching, but for those that are watching and you're speaking to some sort of technology vendor, make sure that they do really focus on the legal industry and they really do know the compliance and regulatory rules inside and out. Lubna, we come back to you. I mentioned the 2021 compliance conference last year. And I was fortunately there, not as a speaker, but I did go and support my team. In that conference, the SRA mentioned that within some of the research that they've conducted, some of the key barriers for law firms implementing technology, buying technology, includes a lack of internal skills, a lack of resources to train someone new, or even just a lack of money to actually bring someone in with the needed skills. So the question is, for people like me, the software Verify 365 and other vendors out there, technology vendors, what can we do as technology providers to support sole practitioners, law firms, small to medium-sized firms, get the most out of technology?
Yeah, the Law Society has been looking into this since about 2019, and we've been looking into, I mean, it's almost like going into the ethics side of technology. And we've done quite a bit of research, and we found that there are 5 principles that both those that want to use technology and those that are providing technology can try to follow when they are looking at implementing new systems. So if I can just very briefly go through those. The first one is compliance. So law tech, it has to be underpinned by regulatory compliance. The design, the development, the use of any law tech has to comply with all applicable regulations. The second one is lawfulness. So, the design, the development, the use of law tech, it has to comply with all law. So as well as regulations, which many solicitors are subject to, it's also about the rule of law, making sure we comply with the rule of law. And then we've got capability. It's really, really important that not only the law tech producers, but also those that are going to use the law tech understand the functionality, they understand the benefits, they understand the limitations and the risks that are associated with products that they're going to use in the course of their work. The fourth principle is transparency. So, it's got to be information on how a product has been designed, how it's been deployed, how it's going to be used. That needs to be really clear and really accessible, not only to the person who's providing it, but also to the law tech operator and to the client, because at the end of the day, we're processing client data when we're using these solutions. And then the final principle is accountability. Whatever the solution is, it has to have an appropriate level of oversight, because it is being used to deliver and provide legal services. So really what we're looking at underneath all of this is client care. That's the overarching principle. It comes down to client care. Solicitors have got a duty to act in the best interests of their clients. So the client has got to be at the center of any law tech solution. And it's got to help, it's got to meet business requirements, and it's got to be part of a firm's business strategy. Really, that's one of the main things. The other thing that I'd also add is as well as making sure that products are compliant with regulations, it's also about keeping a record of how it complies with the relevant regulations, and doing that while the product is being designed and while the product is being developed. And then making sure that that information is easily available, accessible, and understandable in a non-technical way to the law tech operator and also to their client.
Amazing. Thank you for that. We have another question from another anonymous LinkedIn user. Please don't be shy to the audience members. We'd love to know who is asking these questions. The question is, we're seeing a growth in software solutions that directly support AML compliance. Should the industry push for more automation adoption in this space? I will actually answer that directly, since I'm one of the few that work in law tech directly, specifically around AML. And the answer to that is yes, absolutely. We should be pushing towards automation in any kind of software solution, because if we can't automate or streamline a system or manual process, then the technology is almost redundant. Pretty much, yeah, it's almost redundant if we can't automate it and streamline the process. We can argue that softwares that that are more manual or more compliant, so on and so forth, but you can keep compliance and you can automate it at the same time, especially around processes such as source of funds questionnaires, address verifications, ID verifications, so on and so forth. Financial verifications, we need extra eyes on that just to make sure that money is legitimate and so on and so forth. But there is a lot that we can automate it and should automate, and arguably that is why AML law tech exists. Lubna, sticking with you, we're seeing the legal industry change quite rapidly, actually, especially since COVID, because that was a huge driver for remote verifications, online consultations such as Lawyer 365, so on and so forth. And over the past 5, maybe 10 years, we're seeing a new generation of lawyer grow up in the industry that is a lot more tech savvy than, let's say, traditional lawyers. So the question is this: should law firms therefore adapt now to changing consumer trends and implement law tech now to ensure that they are immune from, say, losing clients in the future, and that they future-proof themselves with the new generation?
I mean, I think the very simple answer to that, Mev, is yes, 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 really. Legal services are not immune to changing, consumer habits. We're a services sector. Our success depends on meeting clients' evolving needs and expectations. We've seen during the pandemic how quickly we've transitioned to virtual meetings. We would never even have dreamed of having so many virtual meetings 2 years ago, and now it's literally the default mode. And I should say, you made reference in your question to more the newer generation being more tech savvy. I need to just say here that we have done research. Law Society has done research on this area. We have found that legal services are becoming increasingly multidisciplinary, and we have found that solicitors are working on a day-to-day basis with non-legal professionals in data science, project management, and other areas. But I should say that we are finding that more experienced lawyers are really keen to embrace technology as well. They are keen to equip themselves with the skills that they need to keep abreast of trends. That's important. They know that for any business to survive going forward, you've got to keep up with changes in market trends, changes in technology, changes in the way that we provide services. And the more lawyers become familiar with new technologies, and we're talking about things like distributed ledgers, smart legal contracts, crypto assets. The more we become familiar with those, the more adoption rates are going to increase in the legal services profession. And I should just say here, and I'm sure many of the people that are viewing and listening online, a reminder that the Master of the Rolls, Sir Geoffrey Voss, has said that if the legal profession wants to unlock the benefits of innovation and emerging technologies, it has to become familiar conceptually and functionally with those technologies. So, with innovation, we get more flexibility with legal services. We've seen that over the last 2 years. And, at the moment now, we know that we have a judiciary which is very technologically aware. They see the benefits and opportunities of law tech, and the judiciary have made it very clear that they want to see the profession embrace those technologies across the legal system. So yes is the answer.
Thank you for that, Luna. Andrew, we come to you with a question from our audience, which is poor onboarding makes clients unhappy and frustrated. And I have seen this personally where law firms constantly ask clients to come in to drop off documents that should have really been asked at the start in one go, so on and so. So really, a verification and document drop-off takes, say, a week or two versus a day. The question is this from the audience member, however. Can you cover some of the key points for a compliant AML onboarding. So making sure that the client is, making sure the law firm is completely compliant with AML regulations while bringing on that client internally.
No, I mean, I can't just sit here and spell it all out, unfortunately.
But
obviously,
some key points, if possible.
Yeah, of course. Obviously, I'd recommend looking at the LSAG guidance, which goes into quite a lot of depth on this, that we played a big part in writing. But yeah, I mean, obviously, identity verification, confirming who the person is, confirming, perhaps where they live as well, and their likeness is pretty crucial, and that will involve, seeing them or seeing a moving image of them, and then their ID documentation, and that can be a relatively simple process, but perhaps the biggest cause of frustration amongst clients might be source of funds checking. Whereby they're asked to provide some documentation to prove the origin of their funds, and then they're asked for more by the legal practice, and that can be seemingly never ending, until the legal practice is comfortable and that they've got enough documentation to support the origin of the funding that they're going to pass through their client account for, say, a conveyancing transaction. Obviously, as I say, the LSAG guidance has lots of guidance on that, and goes into depth. But obviously, on the technological side now, there's the advent of open banking, whereby it can be managed from a consumer's app, where they can instruct the bank to provide data to the legal firm so that they can take whatever transactional data they need to take out of there to prove out where that funding's come from. So that can make things easier. But yeah, key points are really, confirming who they are, confirming where the money's from, and confirming the purpose of the transaction, and making sure you're comfortable with that before proceeding.
Absolutely. And I will stress to all those law firms and lawyers listening that the main point of verifying their ID and address should be cross legal specialism. So although Paul in his presentation did mention conveyancing being a high-risk area, whether you do immigration, family, criminal, make sure that you do check their ID, check that they are who they are, and address, just to make sure that you're at least ticking those boxes in the risk-based approach that was set out in the presentation. Andrew, we stick with you for another question, which is some time back, the SRA fined Mishkin de Reya a eye-watering £232,500. Now, to us, it's eye-watering. For a firm like Mishkin de Reya, arguably a drop in the water. Nevertheless, one of the reasons they were fined so much was failings around training. So the question is this, and it loops around to Lubna's point about technology never taking over for a lawyer, is how much trust and responsibility should law firms give to software and technologies before really stepping back and going, we now need to take responsibility for this and make sure it is correct.
Yeah, okay. I mean, I can't make further comment on the case you named, but I can offer a view on whether firms can rely on technology. Firms can obviously make good use of technology, provided that they formed the understanding in a tech solution that I alluded to earlier, concerning its operation, and they've embedded it into their processes to achieve compliance with the money laundering regulations. However, they can't place reliance on it as featured in the money laundering regs, because the responsibility for mistakes and failures lies with the firm and not any tech service provider. Those responsible for the AML effort in the firm, such as the COLP, the Compliance Officer for Legal Practice, or Money Laundering Compliance Officer, they should ensure that processes and policies that involve technologies are communicated across the business and that people are trained on them. And we've seen on firm visits that sometimes fee earners are not using technology as desired when managing their own matters, and that can create issues.
Amazing. Lubna, since we mentioned Mishkin de Reya, there's quite a large divide between large law firms of that scale versus small to medium firms. You mentioned contract automation within technology, and contract automation is one of those law tech pieces of technology that, to me, is very much in the realms of quite large law firms that have the resources to bring it in and management. Do you think there is a divide, and granted you've kind of explained this already, a generational divide between, say, let's not call them younger lawyers, but more recent qualified lawyers compared to, say, lawyers that have been in the profession for many decades?
Yes, I think, I touched on this a little bit earlier, Mev. I think, we can argue that those who are more newly qualified are more comfortable in developing new skills, adapting to new technological ways of working. But, I said it earlier, we shouldn't stereotype the more experienced lawyers who've been in the profession for much longer. We can't say, oh, well, they're old-fashioned, oh, they're resistant to change, because they're not actually. They are keen to embrace and to move forward because they know that it's good for business, it's good for clients, it's good for business, it's good for efficiencies, it's good for productivity, and it reduces costs. The Law Society has conducted surveys where we have assessed the need and demand for law tech skills in the profession. And those surveys found a really high degree of consensus right across the profession around the need to adapt to new technology. Far from showing that there is a generation divide, the results of the survey suggested that most people from all parts of the profession are really aware of the need that they need to keep evolving, they need to keep learning as technology becomes more prevalent and as it changes. I'll give you a couple of examples. 71% of respondents to the survey said that they thought that they would need training in the future in data analytics. And actually only 3% had actually had that training. And 44% of the people that responded to the survey said that they would be interested in receiving training on innovation techniques. And only 7% had had that training in the last 3 years. So, the majority of respondents, 4/5 of them, said that they believed that more law tech training would increase productivity within their organization and it would lead to improvements. So overall, 60% of people that responded to our survey, they were supportive. We had a statement that we put out in the survey, which was that lawyers need to become familiar with multiple non-legal technical specialisms such as data science, project management, and design thinking. And 60% of the respondents agreed with that. So, yeah.
Absolutely. No, that was really, really important. And I'm really glad to hear it, to be honest, because definitely technology needs to be used cross-spectrum, whether large or small law firm, whether well-established or newly formed. Andrew, we come back to you, which is, regardless of all the questions I've answered, we know that technology can help law firms with compliance. We do that with Verify. A lot of our other vendors do that as well with other law firms. So we know that technology can help compliance. There's lots of regulations and rules that technology vendors have to follow to make sure that we are compliant to help law firms. But we know it can help compliance. The question is then this: as fraudsters get more sophisticated with the technology they use, with the avenues that they use to launder money through law firms, do you or the SRA think that technology will eventually become mandatory for law firms for, say, AML?
Very good question. I think it might not be proportionate for use of tech to be mandated in the industry, especially where smaller practices might be able to manage the compliance effort between a few people without tech solutions. I think the use of technology will become commonplace, especially as it becomes cheaper and its integration with diverse processes and case management systems that I mentioned operating in the industry is more kind of mastered by providers, and where consumers, grow more accustomed to app-based ID verification, for example. We endorse a risk-based approach where firms conduct ID verification to a reasonable extent, whereby they're confident with who the customer actually is, where the money's come from, and they assemble evidence to support those facts. And obviously, this can be achieved using a blend of manual traditional processes, such as collecting certified paper documents, and using tech solutions as well. Of course, though, if ever in any doubt, firms should always ask more questions to achieve that level of confidence in the client's identity and their funding.
Thank you very much, Andrew. Lumna, final question to you on this webinar. So spotlight's all on you. Similar question, and you have answered this slightly already with your previous answers. Similar question is, will technology become mandatory for law firms, not from a regulatory point of view, as Andrew has discussed, but to increase productivity? As you mentioned, many law firms already appreciate that technology will help productivity. Do you think it'll become mandatory for law firms to have to implement it in some way to help with client onboarding, to help streamline the process of bringing clients in, and ultimately allowing them to streamline everything that isn't the actual matter work?
Well, as you've said, Mev, we've already talked about the fact that, you know, we've seen so many changes over the last 2 years in the post-pandemic world, and technology has played a really critical role in driving recovery as we're coming out of the pandemic across all sectors of the economy, and that is not any different in the legal services sector. Going back to some of the research that the Law Society has done, we found from that research that the adoption of new technologies could reduce the cost of legal services to UK business users by about £350 million by 2030, and double productivity growth in the legal sector. So the economic case is very much in favour of greater law tech adoption. There's no dispute around that. And I think the other thing is that client pressure is going to make sure that law tech does become commonplace across the legal services sector in the future. We're finding that, and certainly the Law Society research found this, that clients are becoming much more tech savvy. They are demanding lawyers to use new technologies. They want to see an improvement in the service that they're getting from their lawyers. They want to see cost savings, and they can be passed on through the use of technology. And that means that market pressure and competition between firms to attract clients is becoming a really significant driver of adopting new technology in the legal services sector. So being able to show that your firm has and possesses technologies that can provide real tangible benefits to clients will be essential when trying to win new clients. You know, technology is becoming increasingly central to a business pitch when you're trying to get new work. So it's clear that the use of technology, it's not just, you know, having technology is just not an added extra or it's nice to have it. It's becoming a fundamental part of the way that lawyers are working. And, you know, that means that it has a significant impact on the way that lawyers can advise their clients. So, for example, with technology, you use technology to do some of the traditional work that law firms have done. So, for example, administrative tasks, like document reviews, that kind of thing. You can use technology to do that, and then the lawyer can focus on areas of work that technology cannot do. So that means adding value on the human side of things. You know, it's you know, the technology is doing the unglamorous legwork behind the scenes, while the lawyer is you know, empathizing with your client. You're building important personal relationships. You're providing advice which is tailored to a specific situation and the needs of the client. So I would say that far from being a threat to the role of a solicitor, technology will be a liberator, hopefully, for lawyers, freeing them from many of the menial tasks that they've had to do to being able to provide really valuable services that their clients need.
I agree with everything you said, especially that last sentence. I couldn't agree more. With that being said, that is all my questions answered. Lubna, Shuja, thank you so much for joining us. Andrew, Brian, thank you as well. And of course, Paul Smith, thank you all for joining us. Thank you to all of our audience members, whether you've watched or listened, especially those that have asked questions. Thank you all so much. Just to remind everyone, this is the second in a 12-part series. So we will be having a webinar in March, titled To Be Announced. Again, thank you all to my panelists, to the audience members. Thank you all so much.